Okay, I'm going to begin. Hello, everybody, and welcome to this evening's seminar. I think we're all just about getting used to virtual seminars and hearings, but we were saying earlier that we do very much look forward to being able to see all of your faces again, and we hope that you're all keeping well. So thank you for joining us tonight. This evening we're going to discuss the implications of ACC, which of course I'm sure you're all well versed in, but we hope we're well placed to talk to you about some of the practical implications of that decision, particularly in relation to health and welfare decisions, public funding, social care charging, and continuing healthcare. For those of you that are joining us this evening that don't know any of us, I'm Francesca Gardner. With me is Eliza Sharron and Arianna Kelly. We are all members of King's Chambers. We are specialist court of protection and public law practitioners, all in different ways. But what we have in common is that we all have a relatively unique practice which spans across all areas of court of protection work, including health and welfare, serious medical treatment, and property and affairs. This evening, we're going to try to talk about and hopefully give helpful guidance on the practical implications of the decision in ACC from earlier this year from Her Honour Judge Hilda. And in doing that, I'm going to start by discussing the welfare applications or steps that may need to be taken following the decision. The court was quite prescriptive in the judgment about what can and can't be done in relation to decisions relating to property and affairs, but it was the guidance in relation to health and welfare was a little bit broader. So I'm going to try and give some examples of where steps that deputies should take may arise. Eliza's then going to talk about NHS Continuing Healthcare, the requests for assessments, appeals, and the limits on the general authority of deputies to pursue appeals following the decision in ACC. And Arianna will conclude the evening covering public funding for those with personal injury awards and social care charging. We intend to go through the talks one by one and then have a general discussion and question and answer session at the end for 15 minutes or so, or however long people want to stay. So please do use the question and answer function on the on your screen, because we'll be happy to take questions at the end and hopefully have a general discussion with you all to the extent that that's possible on this device. So what I will do is I will start with my topic and briefly say goodbye to Arianna and Eliza, and hopefully successfully share my screen with you. I shared it earlier with Arianna and Eliza and displayed my entire laptop. So I shall try this time. As I say, I'm going to try to set out some of the scenarios in which deputies may be required to take steps and or notify the Court of Protection, and I'm going to come back to what notifying means, in relation to decisions relating to health and welfare. The starting point for me, and it has been my starting point, and to be frank, my bugbear for some time now, is what is the dividing line between decisions relating to property and affairs and decisions relating to health and welfare? Because I'm sure that most, if not all of you that are in attendance this evening will have been involved in disputes. They may have been minor, they may have been significant, about the extent to which a property and affairs deputy can become involved in decisions relating to health and welfare. For example, attending at best interest meetings, disclosure of paperwork in relation to care planning, which clearly in my view would extend to issues that the property and affairs deputy needs to be aware of. But there may be resistance on the basis that the hard line is taken, that there is a line between property and affairs and health and welfare. I've had the view and continue to have the view for several years, and I know that the three of us have all advised on several occasions as to where that line is, but my view is that there can't be a line. There are definitely decisions that relate to property and affairs, and definitely decisions that relate to health and welfare, and there is without question a category of decisions that relate to both and then are inextricably linked. And that just keeps presenting really difficult scenarios for deputies. And hopefully ACC has gone some way to clarify what should be done. And what ACC has done for the first time since SRK, the decision of Charles J sitting as the Vice President of the Court of Protection a few years ago, is clarify that there isn't a line, that actually there is a grey area. And it was Sir Honour Judge Hilder who said that, of course, life does not in reality divide into property and affairs issues on the one hand and welfare issues on a quite separate hand. It will sometimes be the case that decisions properly made within a property and affairs authority sit alongside the need for welfare proceedings in the Court of Protection. And she goes on in that judgment to set out what she says deputies can or should do where there is an issue relating to health and welfare that either involves the deputy or the deputy is aware of. And she refers specifically to the decision in SRK of Mr. Justice Charles, which I'm sure you're all aware of, and don't worry, I'm not going to go through it in any great detail, which looks specifically at the issue of the deputy's responsibility where there is a deprivation of liberty arising from P's care package, where it's a privately funded care package and where the local authority doesn't take the required action to authorise it. So there is a developing theme from the judiciary that there is this overlap and that the responsibility of a deputy does not fall squarely within property and affairs, but may actually have some overlap. I've drawn out from the judgment in ACC the aspects of it that I think are relevant, and I just want to rattle through those with you to set the context of what I want to talk about. Her Honour Judge Hilder said it's clear from the SRK case that the responsibility which burdens a property and affairs deputy is to ensure that decisions as they make in management of peace funds result in a lawful situation, which we now know refers to situations that may give rise to health and welfare disputes or issues. And to do that, the deputy is required to alert those bodies with responsibility to take the appropriate action. It must be within the general authority of the deputy to go that far. In an ideal world, the judge said, of course, the responsible bodies would take immediate action. But the question was, what is the deputy's obligation where the responsible body doesn't? And the judge refers to the fact that Charles J had said that the deputy would have to take steps. And what Her Honour Judge Hilder does is tries to add a little bit more detail as to what those steps would be. She said that in her judgment, the requirement on the deputy is to bring the need for welfare proceedings to the attention of the court. So if, having been properly alerted by the Property and Affairs Deputy, the appropriate body or institution drags its heels in referring a non-property and affairs issue to court, the deputy may, without specific authority, draw this to the attention of the court. And she goes further, so the deputy should do that. Now, I think what we're going to do towards the end of the evening is talk about what that actually means to bring something to the attention of the court. And what I'm going to do is focus on scenarios where actually that might need to happen. It's important to clarify that the decision in ACC is not authority for the fact that a deputy is absolved from having any involvement or any responsibility in relation to health and welfare decisions. It is authority for the fact that deputies should take certain steps in relation to disputes and or issues relating to health and welfare decisions. I've set out quite briefly and in really simple terms what the judgment provides that deputies can and cannot do in relation to welfare, and just to hone in then on some of the issues. When I read the judgment in ACC, it was clear to me that it's now established, to the extent that it wasn't before, that there is a duty on the Property and Affairs Deputy to ensure that the decisions they make result in a lawful situation. And the perfect and easy example to refer to for that is SRK, deprivation of liberty. The deputy commissions on P's behalf a care package that amounts to a deprivation of liberty. The deputy must be assured that that's appropriately authorised, even if that means making the application to court. It also establishes that the deputy should bring the need for proceedings to the attention of the court. But what does that actually mean in practice? And to me, that's still a grey area. And I wonder whether or not that's an area that Her Honour Judge Hilder anticipates further litigation in relation to. For those of you that attended our seminar in June or July, I can't remember which date, Honourable Judge Hilda spoke at that conference and made clear that she does anticipate future litigation on this issue and on the scope of the authority of a deputy, and I do wonder whether or not that's something that will need to be considered. The areas then that I'm just going to briefly touch on, as I say, I've talked about deprivation of liberty, and I'm not going to take that any further because you're all aware of it. But then I'm going to go into contact and care packages that may result in restrictions on contact, restrictions of P's access to social media and the internet, and then rather controversially perhaps the disputes as to P's religious observance, because it may seem as though why would that fall within any decision making of a deputy, but there are certainly cases where it may do so. In relation to contact, any health and welfare lawyer in the Court of Protection routinely deals with disputes about contact, and it's without controversy to say that they would routinely deal with cases where there are unlawful restrictions in place in relation to contact that need to be authorised. And what I've done in this slide is just add in some quotes from a case I was involved in a couple of years ago, where the court was critical of a local authority for not referring a case to court where there was a dispute about restrictions on contact. And it, in my view, is an example of quite a common scenario in the Court of Protection where restrictions are in place without authorisation and there's a dispute that needs to be authorised. The relevance of this here is in circumstances where there is a care package that is commissioned by the deputy's funding the care package on P's behalf, and within that care package there are contact restrictions. Examples may be that the care provider is unwilling to allow certain relatives or friends onto the premises and P wants them to attend, or the relatives want to attend. There may be, as I'm sure you've all got experience of, cases of suspected or confirmed financial abuse where P may have been befriended by somebody and that person is then taking steps to restrict P's contact with others. And there are so many different ways that this can arise, but what's clear is that where there is a concern about a person's actions that may result in a restriction on contact, the first step is likely to be that the local authority is notified of any safeguarding concern and or of their obligation to ensure that there isn't an unlawful interference in P's Article 8 rights. But it also may be a completely privately arranged care package that the deputy is aware of, with the deputy is aware that within it there are contact restrictions. And that's a really interesting area that we'd be certainly happy to discuss in the question and answer session, because it gives rise to a scenario where the deputy may find themselves having to either seek authorisation for that or seek at the court's determination on whether or not that contact restriction is in P's best interests, or, as I identified earlier, notify the court of the need for welfare proceedings. So that it's just a recurring issue that comes up in health and welfare cases and in cases of financial abuse that I think ACC sheds light on the fact that deputies may need to take action. Moving swiftly on to the internet and social media, these are all topics that are worthy of a talk in their own right, but the purpose really is to just identify the scenarios in which the deputy may need to take action or think about taking action. Last year there were 2 reported decisions in Re A and Re B that establish that there would need to be a separate assessment to of a person's capacity to make decisions about the internet and social media. It's distinct from any decision about care and contact. And routinely and nationwide, in my experience and my practice, there are care packages, both commissioned by public bodies and from Personal Injury Damages Award, that include restrictions on a person's internet, include restrictions on a person's access to the internet and social media. That might be absolutely properly done and in that person's best interest, but the steps that would need to be taken is there'd need to be a capacity assessment, the best interest process followed, and then identification of whether or not there is an objection to that. Because of course, if there are to be restrictions and or a prohibition on P's access to the internet and social media, that undoubtedly is a significant interference in their Article 8 rights. and if they object to it, needs to be authorised by the court. So again, it gives rise to a scenario where steps would need to be taken by the deputy if the deputy is directly or indirectly involved in that decision. For example, if there are safeguarding concerns about P's ongoing use of the internet and social media, the deputy may be required to put the local authority on notice of that and refer it to the local authority. If there is no local authority involvement, it's a private care package, and the care provider has completed risk assessments to say that P's access to the internet should be restricted, that might be a perfectly proper decision. But in the absence of P agreeing to it, there may need to be an application to the Court of Protection, or the Court of Protection to be notified. And again, we'll come back to what notified means. So again, another complex area in and of itself within the health and welfare jurisdiction of the Court of Protection, the one that undoubtedly strays into decisions relating to property and affairs, both in relation to financial abuse, but also restrictions that may be put in place as a result of a care package. The final topic that I want to just cover, and again, this really could take a whole seminar in itself, is the issue of religious observance. This case from 2017 was the first of its kind in the Court of Protection. It established that where decisions are taken on behalf of a person in relation to their religious observance, again, there would need to be a separate and distinct capacity assessment, and the court gave guidance, and then a best interest decision taken. And the reason it's relevant here is that in the case of IH, I represented IH in that case. And in that case, the question was about the care package and whether or not, as part of that care package, the employed care providers should be expected to shave IH's pubic and axillary hair in accordance with Muslim practice that he'd always observed when living at home. For reasons that were specific to that case, the court determined that it wasn't in his best interests, and in short, the reasons were for safety, and it was considered to be too much of a severe interference into his Article 8 rights, given the intimacy of the procedure itself. But where this may arise, and where a deputy may need to take action, again, could be if there were safeguarding concerns that that was happening as part of the care package, or if there was a request from a parent to do it and there was a concern that that wasn't in P's best interest. Or if there was a general dispute about the fact that that was happening, or if the deputy was concerned that that was happening as part of a care package that was being commissioned out of P's funds, and that the deputy took the view that actually, having read IH, this is something that would need a court order, without the deputy having a view on it, but that because of the significant interference in the intimate nature of a procedure, and there are different, of course, decisions to be taken within the realm of religious observance, it may be that steps need to be taken. And when looking at ACC, it's should the local authority or a relevant body be notified, and in this case it was the local authority and the CCG, or actually is this something that isn't relevant to either body, but is something that should be referred to the Court of Protection in light of a dispute? Just to conclude, and again we're going to revisit some of these issues in the final part of the seminar, but there are clear examples where a deputy's general authority does extend to taking steps that do encroach on decisions relating to health and welfare. The obvious ones being attendance at best interest meetings, particularly in relation to any care and support that's being provided to P, if it's a care package that's funded out of P's own funds, because of course, ultimately, the deputy needs to be assured that any care package or care arrangements for P are in P's best interests. And one rather interesting issue that's cropped up quite frequently, certainly in my practice, is P's use of alcohol, and in certain circumstances drugs, and the extent to which the deputy releases funds for P's alcohol use. Previously, there's been no guidance from the Court of Protection as to any assessment of P's capacity to make that decision. And I know that there are ongoing cases where the deputies feel in a difficult position in terms of releasing funds when P may then go on to abuse alcohol. And the decision from Mr. Justice Hayden, sitting as the Vice President in the Court of Protection in PB, which I've added the citation if anybody wants to read, gives helpful guidance to that. And it gives, I think, an example of a clear health and welfare issue, use of alcohol, that is inextricably linked with decisions relating to property and affairs, because of course of the release of funds for any purchase of alcohol. And it's clear to me that that is a scenario that may give rise to the need for welfare proceedings in the event that there was to be a restriction on the extent to which P could buy alcohol and or socialise in the way that P may seek to do, and or there may be residence and care arrangements to limit P's use of alcohol, all inextricably linked with P's access to finances, but just highlights that grey area and the circumstances in which the deputy may need to take steps. Then I've just added, for the sake of clarity, of course, that the deputy then would take steps to notify the relevant authority of the requirement for court proceedings, and then notifying the Court of Protection, which I think we're going to have a little bit of debate about at the end, because as practitioners, it's not absolutely clear what that would mean. I think we all have varying views, my view being that notifying the Court of Protection would have to be an application of some kind, even if that application were simply to say, this is the issue that the deputy is aware of, this is the relevant public body I say should be joined as a party, and then seeking orders for the discharge of the deputy and hopefully the recovery of costs for making the application. As I say, we could perhaps have some discussion about that at the end. I'm now going to hand over to Eliza, who's going to talk about NHS Continuing Healthcare, and join you all at the end of the session. Thank you.
Thank you, Francesca. I can see that we've had a couple of really interesting questions come in whilst you've been talking about, one in relation to contact and the other in relation to internet use. And I think the way we'll deal with this, as discussed, is to talk about it at the end. So thank you for those questions, and we can discuss those further at the end. Now, I'm going to be talking to you about one of the areas that's identified in ACC as a crossover area, and it's everybody's least favourite topic, I think, which is NHS Continuing Healthcare. And I'm just going to try now and share my screen. And I hope you can now all see that. So there are two issues I want to discuss in relation to this, and it's really the implications in respect of the roles of deputies and issues to be aware of regarding CHC funding in the wake both of ACC and COVID-19 and the new law that's been introduced in relation to that, both of which has really significant and far-reaching implications in respect of how this issue is dealt with. And I'm going to be really addressing over the next 15 minutes 3 issues. Firstly, looking at what Her Honour Judge Hilda says about a deputy's duties in relation to CHC funding in ACC. Secondly, to look at the Coronavirus Act and the new legislation that's been brought in, which affects the processes in place regarding CHC funding. And thirdly, just to look at some of the practicalities and implications in relation to these changes. So firstly, again, I'm sure you will have all read the ACC judgment, but essentially Her Honour Judge Hilda draws a distinction between different types of public law challenges, which you say, some of which she says are financial in nature, others are not. And Her Honour Judge Hilda draws a distinction between CHC funding applications, where she considers that the CHC assessment criteria is not financial, but the decision is, and applications for EHCP plans, where Her Honour Judge Hilda differentiated those applications, noting that the assessment criteria is not financial and neither is the decision. Again, there may be some scope for debate as to whether there really is a difference between these types of applications, where all are essentially about assessing need and identifying funding streams to support need. But essentially the position that we currently have is that the judgment of ACC makes clear that where there is a CHC assessment, making that application is within the general scope of a deputy's authority. And the judgment sets out that the deputy can take advice on whether an application is required without seeking specific authority, and make an application for CHC funding. And of course, I think it's right to point out that there isn't really a very onerous process involved in making an application for CHC funding. It tends to be a request for a checklist to be carried out that might be made directly or communicated via the social worker. And then there is a staged process that follows, which I'm going to just briefly recap on. But essentially, the judgment's clear that the deputy can take those initial steps, and then once the eligibility decision has been obtained, the deputy can seek advice on the merits of any appeal if eligibility is refused without seeking any specific authority. But the deputy cannot go as far as to deliver the letter of appeal, which is how an appeal of the eligibility decision is triggered within 6 months of the decision being made, and cannot conduct the appeal on behalf of P, and that a deputy requires specific authority to take these steps, otherwise they are at risk on costs. So there's a limited authority to go as far as seeking advice on any appeal, but if a deputy wants to take the matter further, they need to seek authority. And obviously it's important to use that 6 month time frame to take those steps and seek authority, so as to ensure that you don't fall foul of any limitation on time limits. Now, depending on the type of practice that everybody has, people will be more or less familiar with what the CHC process actually involves. But just by way of a quick refresher, as no doubt you will all be aware, the process starts usually with the CHC checklist, which is the screening tool. If P passes that checklist, they go on to the DST, which I'll come to next. But if negative, there's no direct appeal process that you can follow in respect of that decision. But you can request another checklist be completed by the CHC, by the CCG, and for the CCG to reconsider that decision. Or you can use, and following that, you can use the CCG's complaints procedure and or refer the matter to the Parliamentary Ombudsman. So there isn't really a formal appeal process or litigation process that can be followed here. And I would suggest it is presumed from the re-ACC judgment that a deputy would be able to follow those steps if there's a negative checklist carried out. If a person is found to be eligible to go forward to the main assessment, the decision support tool, then this is the full assessment that will be carried out by the multidisciplinary team to consider eligibility. And the process of appeal in relation to that is for a letter to be lodged within 6 months of any decision, or not lodged, but sent to the CCG. That would trigger the local dispute resolution process, which would normally take place within 3 months. If the decision is still negative, there's the opportunity to request that NHS England convene an independent review panel to reconsider the decision. And again, that request must be made within 6 months, and usually the independent review panel will be completed in 3 months. And if all those steps are completed and you're still not satisfied with the decision, a complaint can be made to the Ombudsman. If a person is found to be eligible, then obviously it follows that a package of support will be put in place, and there would usually be a review at 3 months and a 12-month review thereafter. So that is the situation as it stood before the COVID-19, the new act was passed, and setting out what role following ACC deputies would be expected to take in respect of those steps. There has now been a substantial change in relation to the landscape brought in by the Coronavirus Act and Section 14 in particular, which effectively suspends for the emergency period, however long that may last, the duty on CCGs to carry out CHC assessments, the duty to carry out FNC assessments, which are funded nursing care assessments, and the duty to have regard to the national framework. And so all of these duties have been suspended indefinitely during the emergency period. Even though there is still a power to carry out these assessments, there's no obligation on CCGs to do so. And it strikes me that there's been relatively little discussion and publicity about these changes as compared to the easements that were brought in relation to social care charging, which has received a lot of attention, even though they've been very sparsely used. But certainly in the cases I've dealt with, most CCGs are now operating under the revised framework and are taking advantage of the new provisions which relieve them of the duty to carry out these assessments. Now, further detail is contained in the hospital discharge service requirement, in particular Annex G, which essentially provides that CHC assessments are not required for patients on hospital discharge pathways and in the community, that timeframes for reviews and appeals will be relaxed. So it's important to note that if you want to challenge an eligibility decision, it's still important to comply with the 6-month time frame on behalf of P, but the CCGs will be able to take, and NHS England will have a greater period of time, and there's no fixed time limit given for when reviews and appeals will be undertaken, and a proportionate approach will be taken in relation to 3 and 12 months reviews of packages. So again, there are no fixed timescales for how CCGs should manage these reviews. There is an important new pathway called discharge to assess, and a specific COVID-19 budget allocated to fund patients being discharged on this pathway. And this provides that patients must be discharged from hospital as soon as it's clinically safe to do so, within 2 to 3 hours of that decision being made. And they may be discharged home with a package of care or to a residential rehabilitation or nursing placement. And the purpose of this provision is obviously to avoid protracted disputes about where people should be discharged to, whilst that patient is bed blocking, essentially, to relieve pressure on hospitals so that they can accept COVID-19 patients. And the system provides that if a patient objects, then there will be an assessment and review of where they should be residing in the place of discharge. So it will no longer be patients remaining in hospital whilst these decisions are taken. And patients will be escorted from hospital to their discharge destination following the end of the relevant period, which seems like a very dramatic set of provisions. And I've not seen many cases so far where this has been implemented so strictly, and I'd be interested to know whether anyone else has. But of course, it does raise issues regarding putting in place care packages very quickly in relation to people being discharged from hospital, and ensuring that people's Article 5 rights are being upheld, and that if any objections are raised in respect of the discharge destination, that they're dealt with promptly and brought to court if necessary. Now, discharge to assess is funded by the COVID-19 budget, which essentially means that the NHS will fully fund new or extended out-of-hospital health and social care packages, and these apply to people who would otherwise be staying or admitted to hospital to allow quick discharge. And it's important to note that that applies both in relation to health and social care needs. And I've certainly got one case at the moment where he was in hospital with various ailments in relation to leg ulcers and sores, and she was discharged home promptly with a package of care which is mainly domiciliary, 4 calls per day, which she objected to, but which is being funded out of the COVID-19 budget, and that will remain in place for as long as the emergency period is in place. It's notable that care packages funded under this budget are not subject to an eligibility assessment in the way that social care packages are, or in the way that CHC funding is assessed. And if he is ultimately found not to be eligible for CHC or to have been self-funding, it's not necessary to pay back the money provided under this stream. So in terms of the practicalities and implications of these changes, the most important question, I think, for most people will be what happens to P while CHC assessments are suspended. So there will be some stream of patients who will be eligible for these new NHS funded discharge routes like discharge to assess, and they will have their care catered for. There may also be joint working agreements between local authorities and CCGs, and those will vary from area to area, and if they're said to apply in your case, then it's important to request details of what those are. It's also the case that CCGs must identify and log details of any individuals who may need CAC assessments after the emergency period, and CCGs are being encouraged to carry out at least checklists, the screening tool, to identify those people that need the full assessment when the emergency period ends. So any request should therefore still be made and evidence in writing to CCGs if CHC assessment is requested. You can still request reviews and appeal decisions, and it's important to comply with the time limits for that, even though the CCGs may respond in a more relaxed time frame. It's important to try and seek completion of the checklist so at least the full DST can be carried out, either when the CCGs feel they're able to accommodate it or at the end of the emergency period. And the reality is it's likely that if P is self-funding, that they will be required to continue self-funding their care throughout the end of the emergency period. But you can make retrospective claims at the end of the emergency period. And therefore, in order to try and protect P's position as much as possible, it's important that those requests for CHC assessments are made promptly and recorded with a request for retrospective provision, and that records are kept which demonstrate any level of need or any change of need, and that evidence is collated from any sources that may be available, whether it's carers, the care home, people within the MDT, identifying what the change in need is, and that all records of cost are kept. So that is my whistle-stop tour through the CHC changes that have come about as a result of ACC and the COVID-19 legislation. The case of ACC is relatively silent on what happens in relation to social care charging. And I noted Arianna popping up on the screen there, and I was just going to hand over to Arianna at this point. To
I apologize. I didn't want to step on your toes there, but thank you for passing over, and I'll see if I can be the one that manages to mess up the screen sharing or not. Thank you very much for handing over. Now, I think as Eliza pointed out, you've all chewed over ACC significantly, so I won't belabor some of the text of it, but one of the points that I think is very interesting that's gone unaddressed in ACC so far is specifically what will happen to people who will be looking for care packages under the CARE Act. The judgment specifically looks to people who are getting education, health and care plans and people who are getting NHS Continuing Healthcare, but it doesn't look at CARE Act provision at all. So I'll just be taking you through what the judgment does say and then giving some speculation as to where it might be going from here. So first, the deputies had argued in the case that the general authority of a deputy included obtaining initial advice on public law decisions which will have an impact on P's property and affairs. And in considering the general authority of a deputy, as I say, the court looked to questions of EHCs and CHC. I think context is really important here. In ACC, the quote-unquote application for an education, health, and care plan that the deputy was pursuing followed on a decision by the local authority that the person's educational needs could be met in mainstream education. So in reality, when the court was talking about an application for an education, health, and care plan, this was an appeal to the decision by the local authority that the person did not require SEND provision in a residential educational placement. They were taking the view that instead the person's SEN needs could be met in regular education. So this is why in the decision they were immediately jumping ahead to questions of going to the tribunal and seeking advice on a challenge to a public law decision. And I think this is something Francesca had pointed out earlier, as well as Eliza. The actual act of making an application is in some ways the easiest part of this. When you're looking at applications for CHC or an education, health, and care plan or CARE Act funding, I would take the view that this isn't really an application at all. This is a request. This is an email or a phone call to ask someone to go ahead and write this decision up for you. Under the CARE Act, Section 9 CARE Act, a local authority has an obligation to assess any person who appears to have a need for care and support. When I'm advising local authorities on this, I always take the view that this is an incredibly low bar. There's no requirement from the person to go into any detailed explanation for what their needs might be. And certainly for most people who will be having a deputy overseeing their care needs, there'll be ample evidence to suggest that this is a person who does have some level of care needs. The CARE Act is also very explicit that a CARE Act assessment is a service within itself for a couple of reasons. One is that it's important for the local authority in fulfilling its information and advice duty to the person. It's also important for the local authority's duty to make sure that they're taking steps to prevent whatever needs can be prevented. So I've always been hard pressed to think of a scenario in which a person who considered that he or she had needs, or a family member or person interested in the welfare of a person who considered that that person had care needs, should ever be refused a CARE Act assessment if they're seeking it. As Eliza was mentioning, a CARE Act assessment, unlike a CHC assessment, takes two parts. First, there's a question of what the person's needs are and whether or not they meet the eligibility requirements for care. As I'm noting this slide, this is determined on the basis of what the person's needs for care and support are, and this can only really be determined following an assessment and the application of the eligibility criteria. Something I'll be talking about a little bit more later, and something I find often causes tension between deputies and local authorities, is that there is often an enormous gulf between the level of care which a person with a PI award might be able to obtain using their private funds and what a local authority considers is necessary to meet a person's needs. This is often a source of tension. It's often a source of disagreement between deputies and local authorities as to what the appropriate level of care is. And in my experience, has often led to many letters before action to local authorities stating that the deputy disagrees with the needs assessment and feels that the direct payments and personal budget which are being offered are totally inappropriate. The second aspect of any CARE Act assessment, and this should be done after an assessment of needs, because as I say, a needs assessment is necessary to determine all of the local authority's duties to the person, is an assessment of financial eligibility. And this depends on the extent and structures of a person's finances relative to the charging rules. I'm sure many of you have filled out these forms ad nauseum in terms of listing the person's assets, but I've also found in my practice that this is, again, often a source of tension between the local authorities and deputies in terms of what a person is entitled to, particularly people who have significant assets of their own as a result of PI awards. To my view, looking at this and looking at the distinction that was drawn in ACC between education, health, and care plans, in which the court found that the decision was not financial and nor was the outcome, versus CHC, where the court found that the decision wasn't financial, but the outcome was. I would take the view that a CARE Act needs assessment is at least as financial as a CHC decision if we have to group everything into one side or another, which, as Judge Hilder rightly points out, is not always possible. CHC care packages can generally not be topped up. There are some limited exceptions to this, which I'm sure, again, many people have encountered in their practice, of lifestyle payments, which are sometimes suggested by providers or requested by a person. In the case of lifestyle payments, these should generally only be used in scenarios where what is being paid for is not considered necessary to meet a person's needs for care and support, but it's something extra and preferably severable from the overall care package. Unlike in the CARE Act, a local authority may go ahead, do a needs assessment, draw up a care plan, draw up a personal budget, and give a direct payment to the deputy. But the way that that's used could be totally different from anything that's actually being suggested by the local authority about how needs are being met. Certainly, I've seen many cases in which local authorities take the view that an appropriate way to meet a person's needs would be in a residential setting, and they draw up a personal budget showing how the person's needs could be met in a residential setting and the cost of doing so. But the deputy uses the public funding, combines it with private funding, and provides a package of care within the person's home or the community, which is much more extensive. So to that end, I would take the view that this is a financial decision, because often what is being sought by a deputy is a funding stream. And in relation particularly to some of the financial eligibility criteria, these are in many ways purely financial. They're a question of statutory interpretation and regulations, which have nothing to do with the person's welfare. They're really just about what the person's entitlements may be. My view is that a request for assessment
will not be an application and wouldn't require specific authority. As I say, I think in any event, there's probably very little in this, because what you're talking about is just telling a local authority that there is a person within their area who has needs for care and support. And again, they should liaise with the person's case manager or other appropriate people who are currently involved in the person's care. It wouldn't be more work than that. It wouldn't necessarily require any, I wouldn't see that it would require any legal advice just to ask the local authority about it. However, where the rubber would hit the road, and where it certainly seemed to do in ACC, was when those decisions came back and people were unhappy about them and felt that they did not represent a lawful means of meeting the person's needs. What steps can a deputy take from there? Now, my view would be that if a dispute is related to eligibility on the basis of needs, probably the safest thing to do is to seek authority before proceeding. However, this obviously puts you in some difficulty, because in order to seek authority, there's got to be some view as to the likelihood of success and the likely costs of pursuing this. So you're in a little bit of a catch-22 in terms of how you can make an application to the Court of Protection to show that this is an appropriate and proportionate use of the person's funds in their best interest, without having a clear read on what the likelihood of success is. I think to this end, again, as I would say, my view is that this is just as financial a decision as a CHC model. And insofar as you can pursue CHC up to getting some legal advice about it, I would say you can probably also do that under the CARE Act, and I think ACC would cover that. However, as I say, not all disputes are center around the basis of the needs assessment. Many of them are on the basis of financial eligibility. And I've seen many, many cases in which local authorities and deputies argue Tinsley-related points around entitlements to public provision of care. To my mind, these would be purely financial disputes rather than welfare disputes. Again, you can always look at making an application just to cover yourself and be on the safe side, but my view is that discussing a person's entitlement on the basis of financial eligibility and even seeking legal advice on that would be something which would fall within the general authority of a deputy. I have a couple of quick points, which I'll try to make as quick as I can, in terms of issues which I commonly see when I spend many, many hours of my life answering letters from deputies to local authorities about requests for care. In disputes over needs assessment, one of the single biggest issues that I see local authorities and deputies fighting about is this disconnect over the standard of care, which is recommended in PI proceedings and not on offer by the local authority. We actually just recorded a podcast recently around double recovery issues, which hopefully should be coming out if that's of interest to anyone. But I think something I often hear from people on the PI side is that what they're looking to in terms of getting a PI award for someone is to put them back in the situation they had been if they had not been injured, and to try to create as positive a quality of life as they can for the person. On the other side, the local authority side, obviously the well-being duty and the well-being principle is to look after the person and to promote their well-being to the greatest extent possible. But in reality, what the duty of the local authority is under the CARE Act is to meet eligible needs for care and support. And it's just a question of meeting those needs, not necessarily making the person's life be as though they did not have the disabilities which led to those needs. So it is a fundamentally different question. And I see this is often where local authorities and deputies end up with loggerheads on this point, in terms of whether what the person is receiving now should be what they continue to receive, and the local authorities view that had they been looking after this person from the start, they would be meeting their needs in a very different way. What I think is crucial in relation to potential judicial review issues around this is that the local authority is obliged to consider and take a rational decision if it's rejecting evidence which is produced on behalf of the person as to what the person's needs are. This is something I see in a couple of different contexts, and there have been several successful judicial reviews over the last couple of years which have focused on this question of evidence being submitted on behalf of a person with needs for care and support by experts, and often by experts in different fields to the person who's assessing the person on behalf of the local authority, which is disregarded. And I think in those cases, the courts often struggle to see that a rational decision could be made to reject that evidence without the local authority specifically engaging with it and giving some reasons as to why it's taken a contrary view. This is always fairly fact specific, and it always looks very much to the process that the local authority has undertaken. But this is something, again, I see coming up very regularly, is just the utterly talking past each other, that you've got a report from a psychiatrist and you've got a report from a social worker coming to different conclusions, but never really speaking to one another. And I think this is often an area in which judicial reviews can be successful because the local authority hasn't necessarily engaged with the points that have been put to it. Another really key point is one that came out of the Antoniak case. to my view, I think this had always been the scenario under the CARE Act, but it was clarified beyond any doubt a few months ago, is that a need is a need, even if the need is being met. So sometimes, again, I see disputes between local authorities and deputies around the point of this person has a care package, their needs are being met, ergo when I do a needs assessment, I don't see needs because those needs have already been met. Antoniak is very clear that if a person has needs, those should be assessed on the basis of what would be happening to the person in the absence of any care. And this is, again, a really important point, with the only exception being that a local authority has no obligation to meet needs which are being met by an informal carer. If you're unsuccessful in seeking funding from a local authority and or you don't agree that they've made a lawful provision, there are a couple of different routes which can be followed. One, a complaint could be pursued with the local authority within their own internal processes, followed by a complaint to the local government ombudsman. Just to know this briefly, I've seen differing standards among local authority complaints processes, some of which are extraordinarily robust, some of which are less so. I have seen also many local authorities, and I would say an increasing trend towards getting independent complaint reviewers on really contentious cases in order to avoid issues around judicial review in the future. And sometimes I have to say, I think these have been really excellent and have engaged very deeply in some of the issues. There's also been some recent judicial reviews which have, again, trying to push back on the concept of coming to judicial review around care decisions at the first instance and trying to push people more towards complaint processes or the LGO. In relation to the LGO, I would just again note that they've been taking an increasingly strong stance and doling out some pretty hefty financial penalties where they have found unlawful conduct. I think this is really relevant under ACC in relation to looking at the cost to the person, because the benefit of a complaint process is there's almost no cost liability to the person in terms of bringing it forward beyond the work done to bring the complaint to the local authority or the LGO. There's judicial review, which has the downsides being costly and has the 3-month limitation period, but can be really helpful, particularly if there's an urgent need. I would also just mention there is provision left hanging in Section 72 of the CARE Act that there may one day be tribunals around care decisions, but they haven't been established yet. Just a couple of really quick points on financial eligibility, unless I'm being told by any of my colleagues to stop talking as we're running close to the end. In relation to financial eligibility, just a couple of really important points. The Tinsley decision from a couple of years ago, which I know I've spoken about at previous King's events, is very clear that there's no general policy against double recovery. The determination of financial eligibility is always in reference to the relevant statutory scheme. So again, there's no policy for, there's no policy against. It's always just a matter of going through the regulations. The charging regulations are a thicket. They've always been that, and the predecessors, which are largely identical to what the CARE Act charging regulations are, were sometimes identified, including by Mr. Justice Munby, as he then was, as some of the worst subordinate legislation which had ever been drafted. A couple of points I just will bang on very quickly before we can get to some Q&A. Income and capital are treated differently, and in some ways they're treated extremely differently under the charging regulations. I know I've spoken about this at previous King's events, but I would just note that the protections for income under the charging regulations are significantly less robust than they are for capital, which is held by a deputy as a consequence of a personal injury award. When you look at periodical payments and payments out of PI trust annuities, this can be, on a close reading of it, limited to either £20 a week or to the amount which is outside of the personal budget as the amount that can actually be taken into account by the local authority. It's not a complete protection when you're talking about income. I'd also just note the very strong word of caution that PI trusts have to be guarded very carefully in terms of their form. If they're being mixed with non-trust funds or they're moved into other financial investments such as NS&I bonds, they can fall out of the disregard and they can then be taken into consideration when you're looking at a person's financial eligibility for care. So again, always really important to keep these funds separate, protected, and within a PI trust within the 52-week period as much as possible. Finally, an issue which I see regularly arising out of in cases relating to older individuals. I've seen many attempts by wealth management firms to sever joint tenancies, put part of the tenancy into trust, and generally take a variety of steps in order to make a person's ownership in a house in a fundamentally different form than it once was. these are very often accompanied by extremely thin files and notes as to why it happens, and it's usually attributed to inheritance tax planning. I would just sound this as a general note of caution. Local authorities are extremely cognizant of the rules around deprivations of assets. And even if there is a view that a person's share in a house has become valueless as a result of steps taken to put it into a trust or to sever the tenancy, it may still be a deprivation of assets and the person may still be charged as though they actually had it. In relation to whether it is valueless or at all, this is, again, a very untested area of law, and there's authority which points in both directions as it relates to what a person's share is actually worth. I think we're coming very close to the end, and I know we had a number of really good questions, so I'm going to leave it at that. But I think we just wanted to make very clear, we're always happy to have a chat, any of us, as to whether or not an application to the COP would be appropriate under the circumstances. This is something we do all the time, and we're always very happy to have a conversation, particularly given some of the cost implications post-ACC. I'd also just again note that if you are potentially in the realm of considering a judicial review and you need to seek authority before seeking a judicial review, these things do have to be pursued at a matter of tremendous speed, because it always creeps up on you much faster than you ever think it will. So with that, I will stop sharing my screen and come back, hopefully stop sharing my screen, and come back to my colleagues who are now joining us here. And I know we've got several good questions, which I'm hoping they have teed up while I've been yammering on at you about the CARE Act.
I think we've managed to answer a couple of the questions. I'm not sure if everyone can see them on the chat function, but we've got a few left, starting with a question from Chantel in relation to contact and what should be done in relation to a request from a biological mother in relation to an adopted P to have contact with P. It's not clear who Chantel's representing in this situation. And perhaps, Chantel, you could let us know, because it has an effect, I think, on what steps you might want to take. But Francesca, do you want to start off in relation to this one?
Yes, so just looking at the question, thank you, Chantel. As I understand it, the facts are that P is a young adult, he was adopted as a baby, and there is now an issue as to the biological mother making contact with him and the impact that that may have on him and what can be done about that. The question goes on as at the moment there isn't a deputy in place. So I think the starting point really are questions rather than answers, but it strikes me that if there is to be a restriction on P's internet and social media for the purposes of restricting contact, the starting point, of course, needs to be assessing P's capacity to make those two distinct decisions, and then a best interest process followed. If there is a safeguarding concern in relation to the mother and the mother's potential involvement in P's life, then of course the local authority would need to be notified of that. But it strikes me as a perfect example of a case that likely needs to go to the Court of Protection, particularly if you have a person that is trying to make contact with P, but there is a concern about the impact on P if A, that person contacts them, and B, if P is made aware of the fact that he was adopted at birth. So I think there's a few missing pieces of the jigsaw there. I don't know if either of you two wanted to add anything on what we know.
Chantel has just added that she's representing the adoptive mother here. So I think the first point of call would be to try and convene a best interest decision-making process with the local authority. Firstly for capacity to be assessed, and then a best interest.
Yeah, because of course he may not lack capacity in relation to those areas of decision-making.
And then if there's a dispute, and if the biological mother is disputing, then that will need to be referred to the local authority. No, sorry, to the court. And usually it would be the local authority that does that if it's the public body making the decision to restrict the contact. And that takes some of the cost burden off. But of course, if the local authority don't do it, you're well within your rights as the adoptive mother to make that application yourself. So first capacity, then best interest, then court if there's a dispute, essentially. Does anybody else have anything they want to add in relation to that question?
No, apart from there's a tricky argument there about the extent to which P's biological mother would be consulted as part of any best interest process if there's been no involvement in P's life, but that's perhaps making it a little bit more complex than it needs to be, because I think the starting point, of course, needs to be the capacity assessments, and then a decision or response from the relevant public body as to the process of convening a best interest meeting and who would attend that. If we just move through, I'm just a bit conscious of time.
I was just going to throw in one, which I can give a very quick answer to, which I think Eliza touched on briefly, but there was a question about whether it could be argued that educational healthcare plans, or SEN, could be extended to elderly patients. Eliza is entirely correct that SEN, specifically in EHCP plans, are up to 25. However, under the CARE Act eligibility regulations, you are entitled to have needs related to education at any age. So that is something that could be pursued with the local authority, even though it wouldn't be specifically under the auspices of education. It could still be pursued within a care plan overall. So I'll just give that as a quick shot before we go on to the next one.
Should we look briefly at the internet issue? Francesca and I were having this debate earlier on today, actually, about whether or not you need a court application or order to sanction internet restrictions, even where P doesn't object. There's nothing that says that you have to have a court order in relation to this. And of course, there's plenty of welfare decisions that are taken under best interests that hugely interfere with a person's article, well, their freedom of movement, their Article 8 rights. And typically speaking, an application is only really made if that person objects or if there's an issue to it. But I think in considering objection, it is also important to look at the acquiescence, whether that person's really is objecting in different ways, whether they're trying to get online at different times, whether there's an issue or dispute about whether it's in their best interests. But certainly, I erred on the line that unless there is an issue, it's not necessarily something that requires a court application in and of itself. I don't know what everybody else thinks about that.
If pushed, I agree that if there has been a capacity assessment and a best interest process and there isn't an ascertainable objection, then a court application is not required, because the principles of the Mental Capacity Act are clear as long as they're properly followed. It just sits uncomfortably with me, particularly in relation to, for example, young adults who, you know, their means of communication might be, if you read the comments of COBJ in REA and REB, might be largely over the internet and social media. It's the way now that young people routinely communicate, and to restrict and or prohibit their ability to do that seems to me quite a significant step to take in the absence of a court order. So it sits a little bit uncomfortably with me, but if pushed, I agree that in the absence of any obvious or ascertainable objection, there wouldn't need to be authority, but there would need to be clear evidence that the proper processes have been followed.
I mean, just to draw a slightly different analogy, someone undertaking your personal care is quite a substantial interference with your Article 8 or privacy rights, particularly if you don't want it, or you might be objecting or acquiescent. But the best interest decision-making process allows those sorts of interferences, with the court being available to resolve disputes. And it's only a deprivation of liberty that require a specific authorization from the court under the current scheme that we have.
Yeah, that must be right.
Just scrolling through then.
I'm happy to pick up the question from Richard Bremer if that works. The question from Richard Bremer is that, do you think it is just the funds awarded to P in relation to the cost of future care can be retained and passed on eventually to beneficiaries of P, whilst the actual costs of care are met by the local authority? I think this is a really good question. I think there are, in general, when you're looking at funds which are allocated to the person by the local authority in relation to direct payments, there should be a fairly clear accounting of how those are being spent on behalf of the person's care, because almost always, certainly in my experience, there is an agreement within the direct payment agreement that any unused funds will revert to the local authority upon the person's passing, or in the circumstances when the direct payment may be canceled for whatever reason. So I would take the view that there should be some caution around that if direct payments are being used, those funds aren't necessarily to the person in the same way that a benefit would be. That's a fund being paid to the person to manage so that the local authority can buy the person's care. And I think it would be very unlikely that you'd have a scenario in which those funds could be passed on to the person's beneficiaries.
There was a couple of questions from Peter Edwards, one in relation to whether there's a duty to refer these welfare issues to the court, which has been one of the issues that have been vexing us that we've all been discussing. The view that I take is that where the arrangements have been put in place by the deputy, either directly or indirectly, and there's an issue arising, there probably is a duty to refer that to the court. If it's not taken forward by the local authority. But for broader welfare issues that don't touch upon the deputy's authority in any way, my view is that there's no duty to make those applications, although there may be a power to refer them to the court. But obviously, if you start accepting duties to make all of those applications, you potentially have the flip side of that, which is a liability issue if you don't make them. And it would almost impose on the deputies a safeguarding duty akin to the Section 42 duty on local authorities. I don't know whether either of you have any thoughts on that.
I think it can be argued both ways, and we've all had this debate prior to this seminar, because I think there is a little bit of ambiguity in the ACC judgment about the extent to which deputies are required to take action, even in relation to health and welfare decisions that they have no direct or indirect involvement with. And my view, probably unhelpfully, is that you could interpret the judgment both ways. You could, without question, interpret it as saying that in circumstances where you are aware of a health and welfare issue and you notify the relevant local authority and they don't do anything, then the deputy should take steps to alert the court. You could absolutely read it in that way, and read it in that way as to suggest that there is a duty. I don't see legally how there is a duty. I think Arianna might disagree with me, but I think there's certainly now an expectation following the judgment in ACC that an application or notification, whatever that might mean, is made to the Court of Protection if the deputy is aware of an issue and the public bodies fail to take action.
And I think this is a really interesting point, and I imagine this is going to be one that will get touched on in the future. But I mean, I think looking at it from my perspective is that if you are in a position where you have a fundamental concern that there's a vulnerable person, and you've raised it with the appropriate people, you've flagged it up along the ways which are outlined in ACC, you still think that there's a fundamental concern about the person's best interest, and particularly if there is a safeguarding concern about the person's safety. My view is that I would struggle to see that the Court of Protection would take any steps to dissuade a deputy from raising that issue in the COP in that scenario. It has to be pursued reasonably. It has to be pursued with respect to the fact that local authority safeguarding processes are generally going to be the right first stop for any of these, and they may reach a different outcome. But I think, unfortunately, you do see times when the deputy is seeing things in a way that other people are not. They may just be seeing it on the ground on a much closer basis. And if there is a vulnerable person who's in danger, I would struggle to see that you, as a person with responsibility and fiduciary obligation to that person, wouldn't have some obligation to flag that up and to make sure that that is getting sorted out, or at least being raised in the appropriate way. A very interesting question we actually had from an anonymous attendee was, how far would that obligation have to go? Specifically asking, would notifying the local authority, checking with the court system, tip staff, and official solicitor count as sufficient for meeting a test, or would a COP application still be required even if the local authority claimed they had made the application? And again, I don't think there's any clear answer to that. I think it's always going to be a question of reasonableness and whether or not you're acting appropriately under the circumstances. I don't think there's a set formula that anyone could give in a specific circumstance, because it would depend on the gravity of the risk to the person and the information you were getting back from these various people as to what steps they had taken to make sure that P was going to be safe.
Peter makes another interesting point in respect of referring these matters to the court, because of course deputies are likely to be using P's funds, where legal aid may in fact be available for what are welfare issues. And if the deputy makes the applications, they may very well be incurring costs that P would be entitled to legal aid for. So when we look at what referring to the court means, it may well be that referring to solicitors who have a legal aid franchise that can make the application with legal aid on behalf of P would be appropriate, or for an advocate to be appointed as litigation friend to make that application would fulfil that obligation, but in some way progressing the issue towards a resolution. And as Arianna says, there's no fixed rule or line at the moment, no fixed guidance from the ACC judgment as to what that process entails.
No, but I think it raises a really good and important practice point, which is that, you know, inquiries do need to be made as to whether or not there is potentially legal aid available for P in certain circumstances. I've certainly had a case where an application has been made, and in fact another case where a deputy sought to be joined as a party into welfare proceedings and incurred costs in proceedings where P would have been eligible for and would have received legal aid, and the court was extremely critical for obvious reasons. But I suspect it's easy to ascertain whether or not P is eligible and refer the case. I know there's lots of solicitors that specialise in health and welfare work, and we'd certainly field any questions about legal aid, but that's a real point of caution, is to ensure that if an application is made, that there isn't legal aid available for it.
I think with that, we've actually worked through all the questions that have been asked. I've just to put that out in case anyone's got any last minute ones they'd like to flag up. But other than that, I imagine everyone wants to go have supper at some point.
So thank you all for attending and for staying as late as you have. You've listened for quite a long time now. I know that I speak on behalf of all of us when I say any queries, please get in touch, either directly or through chambers. It's an ever-evolving area, and we're all already fielding queries, but you know, please continue to get in touch, and we hope this has been helpful. As host, I'm going to end this broadcast, but as I say, we hope to see you all soon and stay well. Thank you.
Bye-bye.